fundamentals. Why then do I dare to stand before you and sully so beautiful an evening? I think there is some profit in talking about cross-examination, ladies and gentlemen, in this sense. No, I can't, and I don't think anybody can, help you to be a good cross-examiner. But I think that I can help you to avoid being an abominable cross-examiner. And that modest objective is my objective this evening. Let me begin by suggesting to you an approach to cross-examination. I dare say that now, halfway through this session of the National Institute for Trial Advocacy, what I have to say will come as no news. But I'm also prepared to bet you that 10 days ago it may have come to news to some of you, and I'm sure it would come as news to most of the trial bar in the United States. How does a trial lawyer approach cross-examination? Let me suggest my thinking on this by way of contrast. Imagine that we had with us an intelligent man from Mars, someone who knew nothing about our trial system, but he spoke our language and was pretty bright. And he had learned a little bit about what our trial system was like, and then we said to him, "Now, sir, you tell us, how do you think a trial lawyer goes about preparing his case? How does he go about trying it? How does he approach it?" And the answer you might get from that intelligent but ignorant man from Mars would probably go something like this. Why, the trial lawyer walks into court, and he tells the jury what he's going to prove. And the other lawyer tells what he's going to prove, and the first lawyer listens. Now he knows what the other side is going to prove. And now the witnesses testify. And as the witnesses testify, the lawyer listens, and he learns what the evidence is. And then after all the evidence has been received, the lawyer puts it all together in his mind, and he stands up and delivers his summation to the jury, and then he goes out and prays, and the jury decides the case. And if that's what any one of you thinks, you're doing it ass backwards. Every good trial lawyer knows that that's absolutely the wrong way to do it. And if that's the way you're going to do it, you're never going to be a trial lawyer. A good trial lawyer, no matter what the case, no matter what the court, thinks about that case to the exclusion of everything else for whatever time is available to him to prepare the case. Be it, for those of you who work in poverty law offices, be it 5 minutes. You got 5 minutes to prepare the case? Yeah, at most. That's what you think about for 5 minutes. And I know trial lawyers in New York City who, if they have 6 months to try the case, stop reading the newspaper for those 6 months. They don't open the mail because it's distracting. Has another advantage, by the way, if I may interject. Someday you ought to try ignoring your mail for 6 months. You know what you'll discover? Makes no difference whatsoever. Nothing changes. Right? And you save all that time and hassle of answering correspondence and so forth. Right? Your mind is focused upon that trial to a degree of concentration unknown to practitioners in any other branch of the profession and unknown to any other kind of professional. You think of nothing else. You live, sleep, and breathe that trial. And finally, before the trial starts, you reach the point where you have analyzed that case so thoroughly and are so well prepared that you can stand up and deliver your summation to the jury before the trial starts. And if you can't deliver your summation to the jury before that trial starts, you're not prepared for the trial. And let me tell you, if you have done your job, the summation you actually deliver after a week, 2 weeks, or 2 months of trial will be within 90% of the summation you had prepared in advance. If anything more than 10% of that trial is unanticipated and comes as a surprise, you have not done your job.